let's get started. My name is Paul Reidl. I'm of counsel with Dickinson, Peatman, and Fogarty in Napa, California. I've been doing this for over 40 years. I was a litigator with Big Law. Did a lot of work with a guy in New York, this big real estate developers, and Trump's got that guy. Did a lot of work there. I was the number 2 lawyer at Gala Winery for many years, had my own practice. And then I joined my friends at DP&F just because I got tired of doing all the stuff that you have to do by yourself. With me is my friend, Stephen Gould. Stephen's done it all. He's a consulting alchemist and does all kinds of things. And if you don't know him, you should, because he is extremely knowledgeable in everything from distilling through logistics, trade zones, everything. This is the guy, and he's got the experience to back it up.
And let me jump in there. Part of the reason we're on stage together is as some of you know, I ran Gould Distillery for 16 years. I was involved in the alcohol beverages before that, founded a brewery, etc. For whatever reason, my career has had more as a small producer and brand owner share of IP challenges and experiences. And Paul and I met a few,
it was a long time ago, yeah.
And we've done a number of things together dealing with IP challenges that, most small brand owners might encounter one of these in an entire career. I've had, half a dozen?
Yeah, you've had some, yeah.
So we're up here together. I'm speaking as a brand owner that's dealt with it. Paul is speaking here as my legal counsel that helped me as a brand owner get through it. So unlike talking yesterday about parables or earlier today about logistics, I'm here as a brand owner that this man helped me go through challenges that you might face. So that's why we're up here.
Yeah, and I'm really looking forward to it. Now, because this is a massive topic and we only have 50 minutes before we get thrown out for the next group, I'm going to go fast. And the focus of what I want to talk about today is risk management. You guys as folks who own businesses, who work in businesses, you don't have to know all the details of everything, but you do have to know how to issue spot and to manage risk. And that's what we're going to try to communicate to you today, how you do that. Now, we're necessarily going to have to talk about what's IP and all that other stuff so that you know what we're talking about, but the focus will be on risk management. IP refers to stuff that's created by humans, intellectual property. So a chimpanzee who takes a photo with the camera on a tripod, that's not IP. Don't get me started on AI. That's this century's issue, how they're going to sort through who owns what and whether it's protectable. I have no idea. So don't ask. Generally, we speak of 4 kind of groups of IP: copyright, rights of publicity and privacy, patent and trademark. We're going to walk through each of those a little bit. And as I said, what we're going to focus on is how you manage the risk for each. But as I said, in order to manage the risk, you have to understand what the IP is all about. So when it comes to risk management, I've been doing this for a long time. And I met people who are cowboys. I mean, you're like, all right, you're the client. And I never say I told you so. And then I've met people who are almost too risk averse. They want no risk at all, which is impossible when you're dealing with IP. So everybody has their own risk tolerance level, and that's going to vary depending on the project, depending on what you're doing. It's going to vary. And if you work with a good lawyer, they should recognize that and accommodate that to what you're working on today. And I'm working on a huge search project for a company in Europe, and their risk tolerance level is real low. And I bet we've gone through 30 names, but they can't find one that has a low enough risk for them. So we keep going at it. I can tell you other clients would have stopped at name 6, but it's them, that's their risk tolerance, and we need to respect that. Now, you're saying, well, I got insurance. I pay the insurance, this stuff. Well, the problem is that the standard insurance policy doesn't cover trademark and it doesn't cover patent. It may cover copyright and publicity and privacy. So you can't rely on your insurance to help you out if you get a demand letter or get in a jam. And who wants it? I mean, Steve will tell you, dealing with these issues takes up time, it takes money, it's a pain in the ass, and you want to avoid it if you can, right? I mean, you just don't want to do it. So, forget, insurance is good, you'll need it for some things, you need it to run your business, but don't expect it to bail you out in the IP area. The number one way to manage risk is due diligence. An ounce of prevention is always worth a pound of cure. And the way you do that is establish a good working relationship with a lawyer who is an IP specialist, maybe not a patent specialist, but a generalist, knows trademark, copyright, right of publicity, knows enough about patent law to...
And let me jump in on that. Before I met Paul, I had a very good medium-sized law firm that had supported a couple of companies I founded. They had an in-house person that was their IP guy. This is a law firm with 60 lawyers, so it's not a small firm, not a large firm. He talked a good game, but the attention to detail wasn't there, and he really did not know alcohol, beverage, and consumer goods trademarks as much as he might have pretended he did. He was more of a patent lawyer. So just because you have an IP lawyer or someone that's done IP does not mean they're the right lawyer for you as a brand of. And when push came to shove, we had an issue. We'll talk about the Gould and Moon issue further down the line with foreign trademarks. But I ended up getting annoyed with this guy because he wasn't doing what he needed to do. I was introduced to Paul. This is how we met. And Paul had this subject matter expert in the type of IP law that we all care about. And that is consumer goods, alcohol kind of stuff. And Paul was able to very quickly and very cost effectively advocate for my brand at the time and help us negotiate our way out of a mess that, because of the inaction of my prior lawyer, we were in that we actually didn't need to be in from the get-go.
Yes, that is true.
So we'll talk about that more, but it's really important that you, like in my last session, we talked about logistics providers of unfed alcohol beverage. It's the same with mobile beers. So,
yeah, it doesn't have to cost an arm and a leg. Now, litigation, even using me is going to cost money because it's time consuming and there's stuff you got to do. But, it doesn't have to cost an arm and a leg, and you'll sleep a lot easier if you've got some advice from a lawyer. Anyway, copyright. What's copyright? It's a tangible expression of ideas, and it's protected for a fixed period of time. It's not the ideas themselves. You all deal with copyrights. You got a website, you got POS, artwork, you got labels. That's all works protected by copyright. And things that aren't protected are like recipes, titles of books, those sorts of things.
Yeah, I do.
How do you protect? What's the risk? Well, the risk is you're using something that somebody else created. You get a demand letter and you get sued, or you have to stop using it. Copyright Act has statutory damages of up to $100,000 per violation. It can add up pretty quickly. The number one way to protect yourself is always get written permission. Does not have to be a 15-page legal document that you can't understand. It's like, I'm creating this for you. I warrant that this is original. And if it's not, I'll indemnify you. And when it's done, after you pay me, I will assign the rights to you so you own it. Very, very simple. It can be a page and a half when you put the boilerplate in it. So get written permission. Now, you got to remember that there's secondary liability here. So if your website guy screws up you may be liable for it. And I handled a case that was an absolute, it was just tragic, where that's what happened. And they had taken, the website guy had taken stock photography and put it on the demo page as a holding thing. And he had published the page. And what these stock photographers do is they tag all of their stuff. And then they have the bots that constantly sweep the web, just like way back. And if they get a hit, you get a demand letter. And they expect lots of money. So when you use stock photography, make sure you have permission. If you don't, you might get a letter and you might have to fork up a lot more money than just getting permission for the photography.
Let me add one thing to that. If you go out like Shutterstock, I'm just helping my wife stand up any medical practice. And we went out to Shutterstock and we pulled a few images from Shutterstock. Use fees like $10 a photo. But if you don't do it, it can be a lot of money they're going to come after you for. Go out, take the picture yourself, spend the $10 on Shutterstock. It's money well spent, because otherwise you could get really bit hard. And you don't want, back to the litigation comment, you want to avoid litigation at all costs, because it's expensive, it's time consuming, it's emotionally numbing, and it takes your focus away from running your business.
Absolutely. Absolutely. So some of you might say, well, it's in the public domain. Don't try to answer that question yourself, because I do have a client that has well-known people on their labels. These are dead people. They've been dead a long time. We've checked them, everyone out, so that they can defend it. So you can do it, but don't do it on your own, because copyright law, the term of a copyright is really, really iffy. Now, you can do it.
Been, but I'm not going to say who it was, there have been a couple of cases in recent years where the descendants of either individuals or artists that have done works in historic have provided to come back and sue people using those works that are clearly in the public domain. The fact that they're in the public domain and could be argued doesn't mean you're not going to get sued. And again, you're back to litigation, you're back to spending money. Even if you're 100% right, it doesn't mean you're not going to be in court.
That's right. But, if you check it out, you can get, and you think it's a really great idea. Again, it kind of goes back to the risk tolerance. How much risk are you willing to take? Lawyer says, I think this is pretty good. Is that good enough for you? Or do you want to move on to something else? Now, this label, the Gallo da Vinci label, they brought this to me and I said, Leonardo's been dead for 600 years. That's in the public domain. Don't worry about it. I mean, that's an obvious one. It's a no-brainer. In fact, they didn't even have copyright laws back in the medieval days, Renaissance days. So that's copyright. Rights of privacy and publicity. Basically, everybody has a right to control their name, likeness, and image. Everybody. And that's especially true with celebrities. Now, you see newspapers, they got stuff, they publish photos all the time. You're not newspapers. And there's no First Amendment deal. If you use it, you're not protected by the First Amendment. Again, risk management. Get permission. Real simple. Get permission. If you want people to you want to have an interactive website, just put it in the terms and conditions of the website that you can be used for this purpose. Now, celebrities. As I said, I have someone who is a client who has used celebrities, used it successfully. But here's the rub. What happens when the celebrity dies? Do their rights continue or do their rights die? It depends on the jurisdiction. And that's the issue. In California, due to the Astaire Act, your rights continue for a long, 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 long time. In New York, they end on death. And that leads me to the fascinating case involving Marilyn Monroe. A winemaker in California said, well, she's dead, so I'm going to put her likeness and image on my wine. Bam, they got sued by the licensing company in California court. Licensing company said, Astaire Act. She's dead, but her rights live on. We are entitled to a lot of money. Defendant said, not so fast. Not so fast. Because you see, Marilyn Monroe died in California, but her estate was probated in New York. It was filed in California. They filed in New York, and they claimed that even though she died in California, she was a resident of New York. Now, why did they do that? Estate taxes. They saved money. Okay? So now they're going back to the court in California and say, never mind. That never happened. Ignore that. And the court said, no. You argued that she was a resident of New York when she passed. The court found she was a resident of New York and probated her will. She was a resident of New York, which means that the New York statute applies, which means her rights vanished on death. Get out of here. You're done. And the licensing company lost the case. Now, that said, don't put Marilyn Monroe on your spirits bottles, because you'll get a demand letter from CMG Marketing and they'll sue you and try to extract money from you because they don't care about precedent. These guys are real hard asses. Okay, patents. This is something you'll probably never have to deal with, but I need to mention it anyway. A patent is a contract with the United States government. The inventor discloses everything they know about their invention. And in return, if they can convince the examining attorney that it's useful, novel, and non-obvious, and they have their list of claims, they can convince the examining attorney that those claims are indeed useful, novel, and non-obvious. They get a patent, and that gives them a monopoly for a fixed period of years. They don't even have to use it. They just get the patent, and they can stop others from using it or extract license fees. Patents protect ideas, and they don't protect, like the same thing as copyright or persona or trademarks or anything like that. Now, in general, patents are really not going to apply to you for a couple of reasons. Number one, you aren't out there inventing stuff, and I think that anything you think that is useful that you've come up with is probably anticipated by the prior art. Prior art is very, 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 very crowded in this area. And I've seen some patents like for a cork, a plastic cork that was like one of the worst patents I've ever seen. It was invalid. Couldn't believe the examining attorney issued it. So you're probably using off-the-shelf stuff. You buy it from somebody, that's fine. And the second reason why you're probably not going to have to deal with the issue is that patent holders rarely go after end users. They don't. You have Apple suing Qualcomm and Qualcomm suing Apple because, there are all these phones and the components of the phones, and they're not going to go out and sue little guys who are the end users of the phones. Even though technically that's an infringement, they're not going to sue. They're going to go after the deep pocket, the big guys. Now, if you were Gallo, yeah, you might get a demand letter because you've got enough money in your pockets that they would be interested in coming after you. But that's unlikely to happen.
I'll jump in here on this for a sec. So we've all spent at least a little time in the craft spirits industry at this point. And there's a lot of people that come from other industries in our industry, myself being one of them. Most of us probably being one of them. And we've all met those people in our industry that came out of hard science. And professors, they've been researchers, and people always come up with, I've got a better idea than somebody else. Always talked about doing your due diligence. There's nothing worse than seeing somebody that get to know in our own industry, or it could be one of you that has this beautiful idea and spend a lot of time, effort, and money in research. You develop a new technology or new thing that you want to patent, only to find out because they didn't do the due diligence that somebody else, they're all online 20 years ago, 50 years ago, 80 years ago, did the same thing and it's well documented. And I've seen this happen more than a few times. So it's just worth mentioning, well, most of us will never go out and get a patent. There are a lot of people that want to go out, get a patent and be an inventor. nothing worse than spending a huge portion of your life trying to invent something only to figure out it's already been invented.
Yeah, and I should say that patent prosecution is very expensive. It's very expensive. It's just the nature of the beast. It's much more expensive than getting a copyright or a trademark registration.
By the way, one of the places you see this really commonly in still spirits world is the number of patents filed around the world in the last 200 years for age spirits. I have gone back and pulled patents from the British government from the 1800s that literally describe what people have presented in the last 5 years in ADI as a new idea. And I'm like, it's the same thing. It was patented in 1888 in the UK. So it's just keep that in mind as you're thinking of inventing things. Do your due diligence before you spend the time and effort and money and rip your soul to create something.
Good points, good points. Okay, trademarks. That's where we're going to spend the rest of our time. People ask me, why do I care? Well, if you're making a spirit, you're making a blend, you're making the world's best gin, that's your heart. You pour your heart and soul into that. You also pour your heart and soul into how you're going to present it to the consumer, how you're going to name it. Both the product and your brand, those are your babies, and you want to protect your babies. You want to make sure that when you launch and you invest in getting the product out there, that you're not going to get you can't do that because it's my name. So it's very, very important that you go out and protect your trademarks, protect your brands, because that's what you're selling. That's what you're dealing with. So we're going to talk about basic trademark principles, talk about some brand strategy, and then a case example that Stephen and I went through. Trademarks 101. What's a trademark? Well, not everything is a trademark. A trademark is an indicator of a single source of goods or services. And not all terms can be trademarks. Take a generic term, rye whiskey. Can you protect that as a trademark? No, that's the name of the product. Yes, you can't do that. A descriptive term, great tasting rye whiskey, you can't protect that. Anybody can do that. But if you said Stanton Fields for rye whiskey, well, that's protectable. Well, I haven't searched it, so maybe it is. But it's what we call inherently distinctive. It's not a generic name. It's not a descriptive name. It's a term that can be protected under trademark law.
Let me throw in another example.
Yeah, sure.
So, as most you know, I owned for many years Gould Distillery. I still own the Gould trademark brand. Chances are you will see that again in production. Early on, before we called ourselves Gould Miz, I researched trade and Gould. So it's Gould. Now, you can trademark a place name if your product is tied to that place name. Unfortunately for us, or fortunately, I would argue in hindsight, another distillery had trademarked Gould in the distillery. And while that's a color, it's a common name, it should not have been issued as a trademark. They were in some little lake in Washington, and USPTO issued the trademark. And I believe they issued erroneously. I think you and I talked about this. You believe they issued erroneously. I met them. They were two great guys. They made some cool products. And I decided it was fine. I got to find another name. But here they had a trademark. It was, even though it was issued by the U.S. government, was not legitimate because it didn't follow the U.S. government's own rules. So common names, typically common terms, typically cannot be trademarked. If it's a place name, you affiliate with a place name. Well, but here's thousands of towns. I mean, I have this with Laurel Canyon in the section of Los Angeles, which is big in the music world,
right?
But for you to say that it's wrong, I mean, it is a potential place name's description. But for every word like golden, there's 1,000 other words that count. Mm-hmm. So I'm not sure that you'd say it. It's too bad that it happened, but I don't know if that's their only criteria as place names. I mean, I have this whole color, which I come right.
Well, yes.
Place names.
Yes, there were two reasons. Well, place names, It's possible to register a place name, but the rules are essentially that if it is a common, readily identifiable place name, then you can't expropriate it as your own. You can't register it. Like if there's like there's a case involving some weird city in Russia, and they just, nobody here in the U.S. have heard of that. And it's not associated with the goods. It's just fine. But it's more complicated. But in general, place names have challenges. And in this case, there are two challenges because it's also descriptive of a quality of the goods. Okay, I'm going to try to speed it up here because the clock is ticking. Trademarks aren't limited to words. Rhapsody in blue on an airline commercial. What airline do you think of? United Airlines. Just do it. What do you think of? Nike, right. Those are trademarks. Why? Single source identification. Okay, those are trademarks. Now, with Rhapsody in Blue, it's a little different because that's a title of a copyrighted work in the music. I don't want to get into but it would qualify as a trademark. Now, the pirate here, is that a trademark? That's Captain Morgan. That's their logo. You bet that's a trademark. So, what are the trademarks here? I'll just do a quick look. Look at the bottle on the right. Heart-shaped label. Well, that's pretty distinctive. Golden Moon. A Mesa, that's distinctive. Gin? No, that's 45. That's the proof. American Picon? No. That's descriptive. It could. That's, well, I know you did. I know.
I owned and
I know.
To one of
Yeah, I know. I know you did. Yeah.
Products. Lots of, between these two products is what 3 or 4 trademark cases that we got it.
Yeah, and of course, Golden Moon on the American Picon. The fruit design, probably not, because that's sort of the descriptive of the product, and it's more of a copyright issue. Okay, some things can't be trademarks, business names, unless you use it as a trademark. United Airlines is not a trademark. United is. Domain names, dpf-law.com is not a trademark. But if you use it as a trademark, Amazon.com, it's a trademark. Artwork, unless it's a logo, is probably protected by copyright. And of course, generic and descriptive terms are trademarks. You might have heard of trade dress. This is the look and feel of packaging. It is.
It's next time.
It is protectable, provided that the trade dress as a whole is non-functional. So we've got a couple of examples here. On the left is the Gallo brandy bottle. Very distinctive bottle, distinctive label type. The neck wrapper is probably functional because it hides the fill line, but definitely protectable as trade dress. Now, the maker's mark is a little different. Nothing really unusual about the label type or label color, or nothing really unusual about the bottle, but what about that dripping wax? Wax has been used for seals forever, right? But put it on that bottle in that form, and the Court of Appeals said, that sure is protectable. That's protectable trade dress.
So in other words, it's a small producer. You decide to wax seal your beautiful bottle of whiskey or gin, and it drips like that.
Yeah,
you see, sis.
Yeah, it's probably not a smart thing to do. Now, if you just do the normal wax seal, that might be okay. But okay, how do you protect your marks in the U.S.? No trademarks. You have to actually use it. So just by using a mark, you get what we call common law rights, and those are strictly confined to the area of use. So you might ask, why should I register my mark if I get rights by using it? Well, you get national rights. They relate back to the filing date, not the first use date. Prior uses are going to be limited to their geographic use. You get statutory notices. Certain defenses are eliminated after 5 years. It increases the resale value of the brand. And all for the filing fee of $350 plus whatever your lawyer's going to
Let
charge.
me jump in with a quick example there. So I own a brand called Gunfighter American. We're still on it. There's still product on the market. When I first launched Gunfighter, we trademarked it. After we trademarked it, and the trademark was issued and actually issued in the UK and Europe as well, we had a guy in Boulder, Colorado, 30 miles from where my distillery sat. They came to me and said, I had Gunfighter wine and, I want something for my trademark. And we looked at it. Paul said it was like 7, 8 years later, he literally made like 150 cases of wine with small labels on it, sold it out, it was done. And we just said, no, there are probably, in last search, I think there's probably 24 wineries using Gunfighter as a label. If I were litigious, which I am not, you want to avoid litigation, I could probably send them a cease and desist and score around with that stuff. It's not now what's something I want to spend like doing, because there's no confusion in the marketplace and they want to put Gunfighter on your label. They're not arming me. I'm not going to waste my time. They're back to the drip. Suntree will waste her time. Get the resource.
That's right.
Just a quick story.
Yeah, sure. How do you select a mark? Basically, don't put lipstick on a pig. You try to pick a distinctive trademark, although I've had clients pick non-distinctive trademarks and they've worked out just fine. And I'm in a dispute right now with 2 companies. One is the goods are bleachers, portable bleachers. One is bleachers rental and the other one is rental bleachers. And I'm representing the putative defendant. And I'm like, you got nothing to protect, lady. You got nothing there. So you can use a mark or a designation that's not protectable, but you may not be able to stop third parties from doing it. So you can rationally decide that you're not going to register your trademarks because they're not mission critical. But on the other side of that, if you use a trademark knowing that somebody else is using it for the same goods, that's what I would call high risk. Very, very high risk. So you manage it.
We'll talk about
Yeah, you manage the risk by conducting due diligence. You can do searches. You want to preferably have a lawyer do that because there's more to just looking at for the same name, similar name, foreign names that translate the same way. And again, this is a risk management tool, which is whenever I give an opinion, I'm like, this is a low risk, moderate to high risk mark, because it's really, you're trying to assess what the risk is. And that's important because remember, there's no insurance coverage. And in the spirits and wine area, we're lucky because we also can go to the COLA search engine and see if anybody is using that mark or a similar mark. We've talked about the legal risks, attorney's fees, lawsuit damages, injunction, but there are business risks too. And I try to emphasize that to my clients. You lose your investment in branding if you have to adopt a new name. And you're going to lose credibility in the trade. You get it into a distributor and you say, oh, sorry, I got to change the name. And it's like, who is this idiot? What are they doing? And because it's not a covered claim, in your insurance policy, you're paying for it. It comes right out of your bottom line. And that's why you really want to do due diligence. It's not that expensive, and you really should do it. Now, problem solving. You can get a license. You say somebody's out there using a mark that you want to use, a similar mark. Will you license me? Well, there's a quality control obligation, and do you really want somebody controlling your quality? Probably not. Consent. This is one we did with Steve, Principia Wine and Principium Whiskey. And we just went out and said, hey, we don't, even though the PTO thinks that like all of these products are all the same, it's like, you guys all know we did. Go on.
PTO will think that anything Chapter 32 or Chapter 33 on a trademark, which is 32 is beer, 33 is wine and spirits, they view them all as alcohol. Now, They don't.
Yeah, they're all the same. But talking to craft brewers or craft distillers, winery people, they're like, what? We're in different worlds. And most oftentimes you can get a consent. Sometimes you run into a jerk that says, no, I'm not going to consent.
And let me add, we're going to talk about a case, my absence here.
Yeah.
And the problem we had, they essentially stole my name. And we had confusion in the marketplace because our distributor saw all their social media that they threw a ton of money at for their wine brand when I already owned the trademark in the spirits world, and pulled my product out of their spirits books, put them in their wine books, and then my customers couldn't order. And that was a problem.
Yeah, it's a big problem. It's a big problem. So, get a consent. Most times that works. Now, the consents have to be written by a lawyer. They have to have certain magic words in them. You just can't say, I consent to your registry. That'll be rejected. So, and most lawyers who practice in this area, I have a form I've used forever. I adapt it to the specific cases. You need consent. Acquisition, you can acquire the other company. I've seen that done before.
You can acquire the trademark itself.
Well, you can acquire the trademark itself. Yeah, I've seen that done before.
Macquarie took that Pecan trademark.
Yes, they group exactly. They acquired it from Steve. They wanted it. They bought it. Gallo made some acquisitions, and they were kind of head scratchers. But I'm just describing on those. Now, you can also, if somebody's got a registration, and they're not using it, they haven't used it in 3 years. It's presumed to be abandoned. And with the cola thing, you can see if there are colas. You can go to their website. You can just sort of backtrack that with way back, and you can do a little investigation, and you file a petition for cancellation, which we did twice for Blackhawk and Gracia. And
so Blackhawk is a whiskey. Still own that product. That product was sold a little in the U.S., but developed for the European market. And the next Gracia is a Genepe, which I still own the trademark, and that product is probably going to be on the market again in the next year.
Yeah, so you can do things like that to eliminate problems. And, I tell clients, a cancellation petition is leverage. You file it. If you got them and they know it, you'll get a consent. And that's, in fact, I have one of those right now. That's I'm going to be filing next week. And then they'll probably consent. And for some, you can try everything you want, and you just have to adopt a new name, because once you go through all this stuff and you get no, now you've got cooties. And if you use it, it'll be presumed that you're intentionally infringing. So you pretty much have to change. All right, this is the case study that Steve's been alluding to. Pretty interesting situation. The plaintiff, that was Steve, he had a federal registration, had a filing date of September 2008. That was his priority date. The defendant filed an application on November 2013. So Steve had priority. In February of 2014, the PTO rejected the application based on plaintiff's mark. This was back in the days where you didn't have to wait 9 to 10 months to get your examination of your application. But by that time, they were ready to launch the wine and had made a huge investment in it. Social media, all this stuff, blah, blah, blah.
So let me give you a little background. This is Reidl absinthe. It's an absinthe that I developed, that I still own the brand. Absinthe, very niche market. Any of you that want to make absinthe, they're never going to make any money. Nobody makes money in absinthe. Having said that, this was internationally known in the bartender absinthe communities. It's still highly regarded and as Reidl absinthe. And it's a product I'm incredibly proud of as a small distiller. I think that resonates with a lot of you folks. We had the couple of college kids with newly minted MBA kids from strangely older, right straight from where I was. They started a company called Club W Wine. It's bought by the Chinese.com winery. They developed, spent a ton of money developing a wine brand called Reidl. Put out these videos. They probably spent more money on this brand than I spent on my entire marketing in the same year for Gould and Men. And then came to me, and after the trademark was turned down, and offered me a whopping $2,400 for my market. And I laughed at them and said, yeah, no. And it gets worse.
Well, they said, all right, we'll change the name. Okay, well, thank you very much.
They told me.
Well, well, that was before they offered him a little money. That was, anyway, they said they'd change the name. And then what happened? They launched the product anyway.
That's where I started hearing, we can't get your product in California, we can't get your product in Colorado. I was with RNDC, and RNDC just starting to nationalize their database. And somebody was like, Reduce Wine, we've seen all this social media with all these videos. It's miscalculated, classified as spirits that put in the wine list. And suddenly all these bartenders are calling up the store going, why can't we order your product? I'm like, got inventory? Because there was confusion in the marketplace because these people had absconded, even though they didn't really intend to abscond, initially anyway. My brand identity, my trading.
Yeah, and they were not very smart. Had they done a search, they would have seen Steve's trademark in the whole due diligence, and anybody who's a trademark lawyer worth half their salt would have said that's a problem. The PTO said that's a problem. They finally came to Steve and offered him a little money. Steve told him go to hell.
I said,
and then they dug their hole deeper by saying, okay, we'll quit. Man, I had so much fun writing that complaint because the equities were so much in our favor. These guys were just scum.
I said, I don't need any money. I just want you to take your product off the market. I'm not litigious. They said, we have 15,000 bottles in inventory. I say, fine. Yeah, we'll give you 6 weeks to sell now or strip and relabel.
Yeah, we had lawyer to lawyer settlement discussions, and their lawyer, you do this for a while, and when the lawyer is just parroting the party line and his heart isn't in it, and that was the case here. He was trying to make lemonade out of lemons. So we had, and they knew it. They knew it, and as the case sort of started moving forward, I think their management finally figured out that, we're going to go down here and we're going to go down hard and we're going to be on the hook for attorney's fees, and it's willful and deliberate, and we're going to be on the hook for damages big time. So they quit. And we settled. I think we may have given them a use-up period. That's kind of...
Well, no, we quit. We settled. They agreed to pay your legal fees. They said they would quit. And 6 months later, we were back in a meeting.
Yeah.
Because they didn't quit. And I would be willing to bet if you go over do wine, you might actually see some third-party. There's still probably a smaller presence that they claimed they couldn't legos. Don't care because the product was taken out of the market. They actually relabeled it finally with another name to be exact same artwork and sold all those bottles. But we had to threaten them with serious damages before we could get them to do that. And I don't need damages. I'm not a bad karma. You don't want bad karma in the world. There's a lot of people who would have taken advantage of it. That's how it means. And I also didn't need the emotional angst of that. And the small bit you really need to think about that. Who you want to be and how you want to live. But it's one of those situations that everyone in this room could face because we're all putting labels on bottles and selling liquid, right?
To bring this to a close, other than being a good war story, which it is, there's a lesson here, and it goes back to what I said at the beginning of our presentation. There is a lot of risk out there, and it's inherent in what you do. When you label product, you use artwork, you use photos, there's risk. And the best way to manage the risk is to do a due diligence and to have someone on the file as your lawyer who knows what the hell they're doing. If you don't do that, you can be like these guys and just blunder and make a huge mistake, and all of that social media stuff they did, all of the investing they did in the brand, all of the work that their salespeople did to get their products sold into their distribution network, it's all gone. It was gone.
One other thing about risk. I am not litigious, as you've heard. There are people, and people in this industry that are very much so. Being, Suntrade, Person Wax, they'll sue anybody. The Duckhorn family, after his still one of the children, I knew it when I was a ski instructor and used to drink his dad's wine out of the trunk of his car in the parking lot of the skier. The Duckhorn family, and I think they've now sold.
Yeah.
The Duckhorn family would sue anybody that had a duck on. Anybody that had a duck. Period. End of statement. Don't care. They're going to sue you. They have, even if they didn't have a leg to stand on, they were still going to sue you and then do something. It's the other lawyer firm is nothing that. There is people out there like that. There was a woman, I can get her name, doesn't matter, that sued everybody except apparently me, that had a cowboy on their leg for years. And still everyone would call me up going, "You've been sued yet?" I'm like, no, I don't, because he was my lawyer. But got a fighter, I never got sued. The other thing I got fighter, by the way, is I was out when I was younger. And that's actually my likeness on the bottle, so I had more strength in the identity of that product. But she sued everybody else that ever launched a captivate on her leg like her. So that's a type of risk that there's nothing you can do other than due diligence to control. And it's your own response. You need to say, what are the chances? Not only do I have a legal stand on, but what are the chances of it's sued? Because if you have a legal that can stand on, emotionally, financially, it's going to cost you. And if you get avoided, you would.
Yes, and I can say from experience that shit happens. I mean, I've seen lawsuits that have come to my desk, and what? I mean, just really bizarre stuff that, kind of in the fantasy world of the plaintiff. So even if you do your due diligence, there is no guarantee that you might, in the 90s, there was a case where Kendall Jackson sued Gallo over the Turning Leaf label. And of course, I had done the due diligence on that. I didn't think there was any issue. And we were in the midst of a war with Kendall Jackson over shelf sets, which were new, and putting computers out to the sales force, which was new, hard to believe. And Jess Jackson didn't want to spend the money. And we were like running to all the various alcohol beverages offices in D.C. and trying to break that open, for Gallo to do that, because it was an unfair trade practice. And I thought when we got the complaint, that's what I thought it was all about. And I was shocked to find out it was a trademark case. Now, ultimately, we won that. Unanimous jury, unanimous Ninth Circuit. But it was very expensive. It was very emotional and very time-consuming. And frankly, it's just one of the risks of doing business, even if you do it right. So anyway, thank you for coming. Again, it's all about risk management. That's what we want you to come away with from this is manage the risk. Don't be a cowboy. Manage the risk. You'll sleep easier.
Do the due diligence. Internet makes it easier than it used to be. And you may think you've got the greatest name and the greatest image and the greatest label shape, or the greatest invention for that matter. Make sure someone else doesn't have it before you go for it.